SJC 12163, Commonwealth v. John Morrissey.
Good morning, Mr. Chief Justice
Mr. Carney,
and
can you
members of the court.
give us 1 second until we get settled.
Certainly, Your Honor.
Now, good morning, Mr. Carney.
Good morning, Mr. Chief Justice and members of the court. I'd like to make one comment before I begin my oral argument. I want to express my gratitude to the court for expediting this appeal, but I think it's also noteworthy that the Commonwealth, in particular, Assistant District Attorney Graydon, was particularly cooperative in allowing this case to be heard in January. And I want to acknowledge that and thank the Commonwealth for doing so. May it please the court.
I'm sorry, before you go any further, of the status of the underlying case, is it still pending?
Yes, Your Honor.
Does it have a trial date?
Well, the expected trial date, given the tracking, would have been in September of 2017.
Right, but
I indicated that
well, that wasn't the case, though, given the latest order of the judge, right? I mean, that.
when I indicated to the Superior Court that if my client were not released on bail, I would be seeking the earliest possible trial date. And so the justice, perhaps as a courtesy, has put this case on the trial list. But for example, in February, we have 11 cases in front of us. And so the clerk has indicated this is not a case that's likely to go to trial.
Mr. Carney, as it relates to the record, after Judge Feely took the recess, he never came out and said that he had no confidence that this individual could abide by any conditions. Is that
That's
right?
correct, Your Honor. Indeed, he said the opposite.
And your view is, before the recess, he was just ruminating on different factors in general as it relates to 58A.
That's correct, Your Honor. And his statement on page 25 of the record, where he says, when he's ruminating and says some violence can be so extreme, somehow morphed into a quote, the defendant's violence is so extreme.
But on page 31, he does say, in the real extreme, I've said that unwarranted, inexplicable violence of pointing a loaded shotgun at a police officer just trying to do their job. It gave me real pause in this case. He did say that when he came back out.
Yes, he did. I think it would give any justice of the Superior Court pause. There are two issues before the court, and both of them allege an error of law by the single justice. The first is whether Chapter 211, Section 3 can be used by the Commonwealth to appeal to this court a routine bail decision of the trial court. I have studied the cases where the government has sought 211(3) relief and been denied by this court. I have identified 6 factors or reasons why the full bench has said 211(3) was inappropriate. I'll list the 6 very quickly. First, the issue involved a routine trial court decision. Second, the judge's decision was so fact-specific that it's not really applicable to any other case in the court. Number 3, the decision in the trial court is not likely to have a wide-ranging effect beyond the case. Certainly, that's true here. The government is not trying to address a systemic problem in the trial court. Number 5, it does not involve a repeated misapplication of the law by the justice. And 6, the ruling will not prevent the prosecution from fairly presenting its case, as would be the situation if a mid-trial ruling excluding evidence would gut the government's case. Those are the 6 reasons that I have seen this court apply in saying 211(3) appeal by the government is not appropriate.
Mr. Carney.
All 6 of these reasons apply here.
Mr. Carney.
Doesn't that go to the single justice exercise of discretion, that the single justice can act in his or her discretion when an extraordinary set of circumstances presents itself?
If it were extraordinary that a Superior Court justice set bail, then Your Honor is correct. But the single justice has to be guided by the pronouncements of the full court. And so if the full court says, perhaps to each other, with the exception of the chief, that the government should not be permitted to appeal pursuant to 211(3).
It doesn't go the other way either?
No, it does not. And I'm saying that, by other way,
But by other way, are you also saying that defendants shouldn't have the benefit of 211(3) review of bail decisions?
no, Your Honor. And the reason that this court has identified why the Commonwealth doesn't have the right of the defendant is the defendant has a statutory right, and even more importantly, a constitutional right not to be held on excessive bail.
What if a district court judge releases a defendant charged with first-degree murder on a rape triple homicide?
I've had 5 defendants in my career charged with first-degree murder who have been released on bail. 2 of them were released by the single justice after they were held without bail in the trial court. So the decision for a defendant is different because his constitutional right is involved, and that's what this court has pointed to time and again.
Can we move on
Yes, we can.
to the second point?
All right. May I add one other quick point? Denying the government appeal pursuant to 211(3) in this situation would also be considered consistent, I submit, with the legislative intent of the statute. If the defendant is held in the district court, she may appeal that decision to the Superior Court. But if the defendant is released in the district court, this court has held there is no appeal of that release decision by the Commonwealth. I'm simply asking that that same approach be taken to decisions in the Superior Court. Let me move to the second era of law. I submit that it is an era of law for the single justice under these facts to conclude that Justice Timothy Feely made a clear error of judgment in weighing relevant factors, and that his decision fell outside the range of reasonable alternatives of a Superior Court judge.
And why isn't what Justice Hines did itself an exercise of discretion that we review? I mean, I understand that an abuse of discretion can be an error of law, but that's not what you're talking about.
Correct.
So how do we get around to get to where you are, viewing this as an exercise of discretion on the single justice's part?
Because it's so clear that the standard for abuse of discretion was not met by the Commonwealth. It would be similar to this. If a trial court judge allowed a motion to suppress and it's reviewed by this court, no one says that the Superior Court justice engaged in an exercise of discretion in allowing a motion to suppress, any more than she would have if she allowed a motion for summary judgment. If this court reversed, you would never characterize that as an abuse of discretion.
Why wasn't it an abuse of discretion for the judge to rely, if the Commonwealth's take on this is correct, completely on the defendant's remarkable public service, rather than on the issue of whether there were conditions or combinations of conditions of release that were going to reasonably assure the safety of the alleged victim in the community?
Oftentimes, when a justice is elucidating the reasons for a decision, he or she might point to a number of factors, but then identify one of them as having particular weight in the decision. I think a fair reading of the transcript shows that's just what was going on with Justice Feely, because he talked about a number of things. The defendant's employment. He found as facts that his family situation supported bail. He found that the absence of any prior record, the circumstances of this case. Judge Feely was very aware that if this were a situation where someone with a firearm was firing at police, that would be completely different than someone holding a loaded firearm with no impediment to pull the trigger, just pointing it back and forth. And as he told two police officers almost immediately after his arrest, I wanted them to kill me. Suicide by cop. Justice Feely realized that puts this case in such a different category. Indeed, if believed, it would almost certainly lead to an acquittal of the most serious charges. But we don't have to reach that. His language and the fulsome hearing that we received and the back and forth, which I always love because it tells me what the judge is thinking. And in this case, he said, there are three factors I want to bring up. Well, he didn't say there were three until he finished the second one, and I said, may I address it? And he said, I have one more. And he said, I've used this language many times in the past. Some violence, and goes on to describe it, would suggest to him that a person would not abide by conditions of release. And then he invited me to comment, and I took that as meaning, now tell me why this isn't one of those cases.
This is just thinking out loud, in other words.
He's ruminating.
But he did, when he did come back after lunch, I think it was then, he did say that that had been his thought. I mean, that there was an inexplicable act of violence in this case, right?
Yes,
But then had reasons why he thought that was not a reason to hold without any conditions.
correct, Your Honor. And in a sense, it was explicable. The man had spent 8 years in the Air Force as part of a unit that came to,
Well, you don't even have to get there, though,
Yeah,
right? I mean, it
and-
can be inexplicable, but
Right,
what you're
that's what I'm
saying is
saying.
that the judge found that in these circumstances, including the history of his employment, that it was likely he would be, under these conditions, not a danger to the community.
yes, and he certainly did not misunderstand the law. The government acknowledged, candidly, that the issue was not a risk of flight. And Judge Feely, in taking a recess and specifically saying, I'm going to think about this over lunch, is showing what great judges do. They don't make a snap decision. They think about it. And they really give it the kind of thought that informs the exercise of discretion, and then come up with a decision that is within the range of reasonable alternatives here. And then he
Can I
did
just
it.
ask you a factual question? Was there a request by the Commonwealth for exclusion zones?
No, I don't believe so. And my experience in the court is that sometimes GPS is imposed to keep an individual within a place or away from a place, but some judges of the trial court will impose it without geographic restrictions because they want to have probation have the ability to know where the defendant is anytime they want to check.
Well, you can do that with exclusion zones, too.
That's true, but there was no objection about that, and I've had many judges impose GPS without geographic restrictions or exclusion zones. And I had the opportunity once in a case where a client wearing a GPS bracelet, this was a juvenile, participated in a drive-by shooting. And I was shown exactly what you can see, the dots on the map, as to where the defendant wearing that bracelet was. And of course, the end of that story was right in front of the house when the shooting occurred. My point, though, is that probation has an ability, if they want to just check, where is Morrissey? He's at this this address in Falmouth. And just to confirm that nothing has changed.
So what is the role of the single justice in evaluating these decisions? I mean, this was a very difficult decision. Judge Feely gave it a great deal of thought, as did Justice Hines. Is it your view that if we find that it was within the LL standard, that that's an error of law, and the single justice made an error of law in finding that it was outside of the range of reasonable alternatives? Is that the only issue before us, or must we say that Justice Hines' decision was outside the range of reasonable alternatives?
I'm alleging that Judge Hines committed an error of law by saying or concluding that Judge Feely did not weigh the relevant factors and that Judge Feely's decision was outside the range of reasonable alternatives. Just as you would reverse a judge who improperly granted summary judgment or improperly allowed a motion to suppress, this was a decision by the single justice. It constituted an error of law. It's got nothing to do with discretion.
You're saying categorically there is no single justice appeal from the Commonwealth on a bail decision?
That's his
Yes.
first argument.
If you follow the 6 factors that I've noted in my brief, and where the full court has said you do not have
You want us out of that business?
What's that?
You want us out of that business?
Yes, Your Honor. And I think that making this clear by the decision would be helpful. And of course, I note in my opposition to the single justice even considering the matter, this was the first issue I raised. I've been doing criminal practice for 39 years, going back to the Jurassic era. And I've never had a case or been involved in a case where 211-3 was allowed to serve as a vehicle to get a review of a trial court bail decision.
But if it was exclusively based, I know you disagree with this, but if the decision was exclusively based on the sublime public service of Mr. Morrissey, and that might, according to the Commonwealth, be corroborated by certain factors that were not checked off on the 58A form, would that be an abuse of discretion in the context of these allegations of violence and instability?
No, Your Honor, I submit not. What Judge Feely was doing was identifying a range of factors and then in the context saying, the one that really made it clear for me is the extraordinary fact that for 38 years he has been helping others selflessly to his great detriment. And a person who is willing to do that, in essence, will obey my ruling. Okay. I would like to just add one final note.
One final note.
I would respectfully urge the court that if the decision in the Assemble is to reverse the single justice, that the court consider issuing an order to that effect with a full decision to follow.
All right, thank you.
Thank you, Your Honor.
Ms. Graydon, good morning.
Good morning. My name is Ellen Graydon. I'm an assistant district attorney appearing for the Commonwealth. With me is the trial prosecutor, Jessica Strasnick. I did check with her in response to your question, Justice Botsford. The case was scheduled for trial on December 7th. There was no judge available. Ms. Strasnick was available in January. Mr. Carney picked February 6th for trial, and we are unaware of any impediment to the case going forward at that time. I, too, have looked at the cases to determine when it is that this court will will reverse a single justice determination. And it rests on whether the underlying order that the single justice is considering was an abuse of discretion. So there is a long list of cases to which this court can refer, covering a broad range of subjects in which the single justice found, or didn't find, but this court said should have found, an abuse of discretion or error of law below. And that's what happened. Our single justice found an abuse of discretion below.
Do you have any as to determination like this one, in terms of a bail determination?
No, 58A rarely comes up, actually. There are a couple of 58A cases, but they're not in this posture.
Well, there are 211(3)s that come up when the defendant appeals, yes? But not
Yes.
when the prosecution appeals.
Correct. The analysis here should have been public protection. This is not a bail situation. This is a dangerousness hearing under the bail statute. So the issue for Justice Feely should have been whether any conditions can protect the public.
He made two,
found
excuse me, he made two decisions, didn't he?
Yes. He made one releasing him on conditions, and then a second saying he would release him on conditions, but he knew the single justice determined that to be an abuse of discretion, so he was going to hold him. That was the second decision.
That was after, that's not before you. That
No, I
was-
know, but is that what you meant?
Yes,
Justice
I
Holmes?
did. Yeah, so there were two decisions, and it's only the first one that's before us.
The first one is before you, the second one isn't. The second one was at the dangerousness hearing after he was arraigned in
Right.
Superior Court. The first one was a bail review from district court to Judge Feely.
So
that's-
the second determination, whether there are any conditions that would adequately protect the public, comes only after there's a finding of dangerousness.
I'm sorry.
The second finding, that whether there are conditions that would adequately protect the public, occur only after there's a finding of dangerousness, inherently.
Right.
When do you say there would be, in which types of cases would there be conditions that would adequately protect the public to a person who would otherwise be dangerous?
Oh, well, that certainly happens in cases that aren't like this, that have this, as I described it, this trifecta of possible disaster. So where there isn't mental health, or where there aren't mental health issues, where there aren't long-standing alcohol abuse issues, where there aren't repetitive relapses, including while he was in a highly specialized program, where there isn't this, here we have drunk driving, we have refusal to stop for the police, we have running a red light, so dangerous driving apart from the drunk driving. We have the pointing a gun. This isn't random waving a gun. This is pointing a loaded gun, concealing the gun, and then pointing the gun at the police. And we have the domestic violence that started it all. We also have this history between the parties, where the police have been called twice to the home for issues related to impairment. So if you don't have all those factors, that kind of a case might be a case where a defendant is dangerous, but not necessarily should be held. But here, where we have this lineup of his mental health issues, if you recall the description by Mr. Carney of the defendant's condition really made the case for the Commonwealth at the hearing, and that was that he is at rock bottom, that he is suicidal, he's underemployed, he is out on disability, he has lost access to his home and his wife because she obtained a restraining order against him that night. He was facing indictment for very serious charges. All of that combination meant that there were, in the Commonwealth's view, no conditions that would secure the public safety or the safety of his wife.
But didn't
Where the
Judge
judge went
Judge
wrong-
Feely know all of those things?
He
And-
did.
And he certainly understood the relevant factors to consider.
He did. Where he went wrong, though, is he relied exclusively and solely on that one factor that he had an admirable career, a job he was no longer doing, a job, the fact that he was no longer doing it contributed or was the basis for his depression, as his lawyer described it at the hearing. That was the abuse of discretion, to rely solely on that factor. The factor, when you look at the statute, is employment history. That doesn't mean, that means that you've had a job for a certain amount of time, you're responsible, you show up, you don't abuse sick time, and so forth. That doesn't necessarily mean what Judge Feely said it meant, which was that you have an important job.
Where are you getting that interpretation of employment history?
Common sense. That would mean you release somebody who has a marginal employment but has done it for 20 years.
No, I understand
You
that.
hold him, but you release a doctor.
Right, I understand that a judge takes the bail factors and makes different assessments. But doesn't Judge Feely have a right to make that assessment?
I think it's an abuse of discretion when he makes the assessment solely on that factor, which has little or nothing to do, as Judge Hines said in her order, with public safety. The fact that he had a job that we as society admire says nothing about whether or not he will be able to comply with his treatment program, given here where he's relapsed twice, including while he's in a treatment program. And that's what the abuse of discretion was by Judge Feely. When Judge Hines found that abuse of discretion, this court must determine whether she committed an error in finding that, and I would suggest that she didn't.
Why do you say it was the exclusive factor for Judge Feely?
He says the only reason. Judge Feely says it. The only reason.
You don't think he's weighed the other factors in concluding that this was the tipping point for
Or
him?
he's disregarded the other factors.
You think he's disregarded them as opposed to weighing them and saying this is the tipping factor?
I think you can easily read into this is the only reason I'm doing it, that means it's the only reason, that he's not considering the other factors.
So if he did consider the other factors, would it not be an abuse of discretion if he hadn't said this is the only reason?
I'd have a harder argument, I think. But he was very, very clear. This is what swayed him.
Well, it may be what swayed him, but that's not inconsistent with what Justice Hines just said. It's a tipping factor.
The what factor? I'm sorry, Judge.
Tipping factor.
No, what Justice Hines...
I don't mean Justice Hines, I'm sorry. Justice Lank said. That's what I meant to say. That it is a tipping factor because he did make findings about the family. So, yes, he didn't cite it.
But if I could say that, too, I actually think that there's an abuse of discretion in relying on the brother as a guardian. It makes the brother a probation officer, if you will. There is no, I could not find any case where a family member is called upon to assure a judge who has no authority over him. What would it be, contempt? I don't know.
Well, he is on a GPS as well.
A GPS with no exclusion zones when there's been domestic violence at the family home.
Yeah, but, well, okay.
I mean, you have to wonder what's the value of of a GPS that just allows probation to know that he's driving around.
And you don't think that had to do with the fact that the brother provided a place that would be something secure, reasonably secure, as opposed to, being homeless?
We have absolutely no idea that it would be reasonably secure.
Well, didn't the judge have to assess what the brother said he would do? The
brother
brother
said
said
he
there was
has
no
a home.
alcohol in the home, right? And he didn't keep alcohol in the home.
He didn't have any weapons.
He didn't
And
have any
no
weapons.
He goes to work every day. Does he know where the defendant is when he's at work?
But he would, well, I don't know what his wife's situation is. I mean, if he were back with his wife, does his wife go to work too?
The brother's wife?
No, I meant, he's
Brother
not
lives
allowed in
alone.
his own home, right? But I'm just saying that if he had been allowed in his own home, his wife may go to work. I mean, there's nobody, you're saying that because there's nobody there to watch him all the time, that it's not okay?
And that's what was needed,
That somebody needs to
Detention.
watch him all the time?
detention.
Well, wasn't he going to be sent to a program for a 30-day period? And they'd be
Unlo-
watching him?
Unlocked program, unsecure program, and the judge knew that. He was very familiar with the program. So in essence, we're releasing him to an unsecure program with no exclusion zones that protect the wife. And
I'm
we're
sorry,
doing
is the
this-
concern the wife?
I think you said you wouldn't have brought it if it was just the wife.
We wouldn't have, but that is certainly a factor under the statute.
Well,
that-
certainly it's a
that
factor,
that
but
a case
the
concerns domestic
the
violence.
violence to the wife, without justifying it, was not as serious as others we've seen. And I think you have said that it was not that. It was
Correct.
not his striking the wife before he left. It was pulling the gun and the shotgun on the police officers. That's the concern.
Yes. And the drunk driving.
Okay, so if he were to walk away from Gosnold, that would be a violation of his conditions, would it not be?
Yes.
And that could permit the judge then to issue an arrest warrant for him for the violation of those conditions, and the GPS would enable the police to find him.
Well, that's true in any case where there are conditions. The issue is whether he should have been released in the first place.
Well, I understand that, but I mean, it's not as if the judge said, okay, I'm going to release you. The judge released him upon a whole set of conditions, which did at least provide the judge with the opportunity to know that if there were to be any breach of those conditions, there would be the opportunity to arrest him and bring him in.
That's true, but that's a little further along in the analysis. I'm at the point where was it an abuse of discretion to release him, given the factual circumstances presented to
Well, I
the
understand that,
judge?
but I mean, but the issue, as you earlier described it, was whether there would be any conditions that would adequately protect the public. And the judge obviously came to the conclusion that the conditions that he set would be adequate. The conditions matter in the analysis, don't you agree?
They do, and Justice Hines disagreed. So
Well, I
what's
understand, I
before you
understand.
is whether she's
Okay,
committed a
and
palpable
that goes
error.
back to an earlier question. Do you agree with your brother that the issue is whether or not Justice Hines made an error of law in finding that Judge Feely acted beyond the range of reasonable alternatives? Or is it your view that we have to find that Justice Hines acted beyond the range of reasonable alternatives?
The cases don't make it clear. They use the phrase clear error of law or abuse of discretion together without distinguishing between the two. So I'd suggest it's not as clear one way or the other. And either way, I'd say she did not make a clear error of law, and she certainly didn't she didn't abuse her discretion.
On the one hand, during the hearing, when Judge Feely comes back out, he says, "There's one reason I'll consider and impose conditions." Then he says it again. And the reason only. So he says it twice. And yet, later on in the transcript, he's considering all these different factors as it goes to conditions of release, as the Chief Justice was just discussing. So why wouldn't we analyze the abuse of discretion as a situation where Judge Feely didn't rely on just one factor, but a number of factors?
Because he said he was relying on one factor. I think it's very clear.
Okay, thank you.
We would ask that you affirm Justice Hines. Thank you.